transcript of the Supreme Court's, the oral argument in the Smith versus Cain case, it looked to me like at least 4 Supreme Court justices don't even understand the materiality requirement themselves. They think prosecutors are obligated to produce anything favorable to the defense without the materiality filter, when there are Supreme Court decisions that confuse the heck out of the whole standard. There is very clear language that the prosecutor is not supposed to tack close to the wind, and if there's any doubt, produce it. But at the same time, David's right. There are all kinds of cases out there that have refused to reverse on grounds of materiality. I know there are lots of non-lawyers in the audience, and I don't want to get into a detailed discussion of the law and how that could be fixed, but we've just got to get a more clear rule that if there is any question at all, produce it. They're going toward open file as much as we can and affirmatively holding any prosecutor accountable who doesn't do what they're supposed to do. The Department of Justice is now seeking to impose a materiality requirement in Rule 3.8 in every state in the country and at the federal level too. And if they can do that, they completely eviscerate the ethical rule. Because not only do they have the hammer of saying it's not material, they even redefine the view of the case. For example, if there's something, as in the Stevens case or the Merrill case, that is exculpatory of the defense and should be produced, they'll say, oh, that was just said with a wink and a nod. That wasn't really exculpatory. That was just said with a wink and a nod, and they'll take the exculpatory thing and make it inculpatory on that basis. So then they don't have to produce that either.
So to Dean Epps' point and the structure, the Michael Morton Act